What's up, man? How much are y'all doing today? I just leaving church? Awesome, man. Good stuff.
Anthony Parker Sr. was driving his girlfriend Demetria Furman's vehicle home from church, with Ms. Furman in the passenger seat and Mr. Parker's 8-year-old son in the back, when officers Kevin Crawford, Gabriel Hellard, Josh Dorr, and William Keeling Jr. of the 9th Mobile Division of the Louisville Metro Police Department stopped him for allegedly failing to use a turn signal, despite the fact that the body camera footage clearly shows that Mr. Parker had activated the turn signal and used it properly throughout the turn. Mr. Parker immediately pulled over, and the officers approached the vehicle from both sides.
He was already over in there.
I got to do it like that for it's broke.
I got you. That's the reason why, man. That's the only reason, man. Awesome. Do what? Yeah, just because you turned to it. Okay. Are there any weapons or in the car or anything like that?
I just left church, got my son with me, my baby in the car.
So there's no guns in the car?
No.
Any knives?
No.
No. Like that? Oh, man, your hands are shaking like a leaf, brother. Even your face is. I just like people to be honest and straight up with me. Do you have your driver's license?
Yes, sir. My license.
Okay, awesome.
I paid the reinstatement fee.
Yes, sir.
Is
it? Okay, awesome.
I don't have no warrant.
Yeah,
It's working now, but...
I got you. Man, do me a favor, put your hands on the steering wheel for me? Appreciate it. Alright, man, before I have the exit vehicle, do you have any weapons on you? Any guns? Awesome, man. We're mainly concerned about that.
Just left church.
Hey, I'm gonna get him out, I'm gonna get Dad out, and we're gonna go to the back, and then we'll get you out here in a second, okay? Spread the feet a little bit more for me. Spread the feet. Oh, yes, sir. Thank you. That's right, we're just gonna come back to the rear of the car.
After falsely claiming that Mr. Parker did not use a turn signal, the officer removes him from the vehicle and asks for consent to search him. Mr. Parker agrees, and the officer thoroughly pats him down and searches the contents of his pockets. The officer also asks Mr. Parker for consent to search the vehicle, but it is unclear from his response whether Mr. Parker was consenting to a search or simply telling him that there was nothing illegal in the vehicle. However, even if the officer received valid consent to search the vehicle, it is important to note that any evidence that was discovered from either of the searches would be inadmissible in court under the so-called fruit of the poisonous tree doctrine. As the Supreme Court explained in the 1984 case of Segura versus United States, quote, "The exclusionary rule reaches not only primary evidence obtained as a direct result of an illegal search or seizure, but also evidence later discovered and found to be derivative of an illegality or fruit of the poisonous tree. It extends as well to the indirect as the direct products of unconstitutional conduct." While there are exceptions where this doctrine will not be applied, such as when the connection between the illegal police conduct and the discovery of the evidence is too far removed, or when the police also discover the evidence through an independent source, it is well established that any evidence discovered through a consent-based search during an illegal seizure must be excluded from court, absent the existence of an exception. For instance, in the 1983 case of Florida versus Royer, the Supreme Court held that because an individual was being illegally detained when he consented to a search of his luggage, quote, "the consent was tainted by the illegality and was ineffective to justify the search." While one officer talks to Mr. Parker, another officer removes Miss Furman from the vehicle, pats her down without asking for her consent, and questions her. As we have discussed many times on ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that, quote, "Once a motor vehicle has been lawfully detained for a traffic violation, the police officers may order the driver to get out of the vehicle without violating the Fourth Amendment's prescription of unreasonable searches and seizures." Although the reasoning for granting this authority centers around so-called officer safety, officers are permitted to routinely remove both drivers and passengers from vehicles, regardless of whether they actually have any reason to be concerned for their safety. However, as the Supreme Court held in the 2009 case of Arizona versus Johnson, quote, "To justify a pat-down of the driver or a passenger during a traffic stop, the police must harbor reasonable suspicion that the person subjected to the frisk is armed and dangerous." In this situation, in addition to the fact that there was no legal basis for the traffic stop itself, there was absolutely no articulable evidence the officer could point to that would even remotely suggest that Ms. Furman was armed and dangerous. This means that even if the stop itself was lawful, the officer would not be able to constitutionally justify the pat-down frisk he conducted on Ms. Furman. Despite the lack of clarity as to whether Mr. Parker consented to a search of the vehicle, the officer searched the entire car and the objects inside of it, including Ms. Furman's purse, without asking Ms. Furman, as the owner of the vehicle, for consent. In the the 1974 case of United States versus Matlock, the Supreme Court explained that, quote, when the prosecution seeks to justify a warrantless search by proof of voluntary consent, it is not limited to proof that consent was given by the defendant, but may show that permission to search was obtained from a third party who possessed common authority over or other sufficient relationship to the premises or effects sought to be inspected. Applying this standard, courts have consistently held that the driver of a vehicle has the authority to consent to a search of that vehicle, regardless of who owns it. For instance, in the 2010 case of People versus Minor, the Supreme Court of Colorado noted that, quote, multiple circuits have applied this logic to vehicle cases in which the driver, who has common authority and a sufficient relationship with the vehicle, consents to a search, and ultimately held that, quote, a driver with control over a vehicle possesses the authority to consent to a search of the vehicle, even if the car owner is present as a passenger. Additionally, in the 1991 case of Florida versus Gimeno, the Supreme Court held that when an individual gives an officer consent to search a vehicle, the officer can also search bags or other containers if, quote, it is objectively reasonable for the officer to believe that the scope of the suspect's consent permitted him to open a particular container within the automobile. Therefore, if a court concluded that Mr. Parker did consent to a search of the vehicle, it would likely find that his consent was sufficient for the officers to conduct the search, despite the fact that none of them asked for Ms. Furman's consent, and that Mr. Parker's consent would likely authorize the officers to search most of the containers in the vehicle. However, because an officer cannot search an object on the basis of the consent of someone who does not have actual or apparent authority to authorize the search, a court could conclude that the officers did not have valid consent to search Ms. Furman's purse.
I gotta double push my
There's
hazard.
a lot of the Monte Carlos like
Yeah,
that, man.
I gotta double push the hazard. Like sometimes it'll work, you know, you hit it like normal, but then sometimes I gotta double push the hazard for the foot to even come in. So that's probably what happened. Like I didn't even know I didn't use it. I used it, but I didn't know it didn't come on.
Okay.
That's my,
You good? Yeah. Sweet. All right, man. I'm not gonna harp on the OL or nothing like that.
appreciate it.
No problem, man. You guys are good to go.
All right.
After thoroughly searching the vehicle and finding nothing illegal, the officers allowed Mr. Parker, Ms. Furman, and Mr. Parker's son to leave without issuing a citation. On August 7, 2019, Mr. Parker and Ms. Furman filed a federal lawsuit against the officers, as well as the chief of the Louisville Metro Police Department and the head of the 9th Mobile Division. In the complaint, Mr. Parker and Ms. Furman's attorneys, who also represented Breonna Taylor's family, alleged that the 9th Mobile Division regularly engaged in deceptive and unconstitutional practices during traffic stops. For instance, the complaint stated that the officers conducted traffic stops in a manner designed to intimidate and trick the vehicle occupants to obtain their consent for searches and detentions by conducting stops with several officers in unmarked vehicles, boxing in the suspects' vehicles, surrounding the vehicle with several officers, accusing the vehicle occupants of appearing to have something to hide, and using quick double negatives to trick occupants into consenting to searches. September 9th, 2021, the city agreed to the $75,000 settlement that allowed the Metro government to acknowledge no wrongdoing and prohibited Mr. Parker, Ms. Furman, and their lawyers from criticizing the Louisville Metro government or the police officers involved in the incident. In May of 2019, the Louisville Metro Police Department announced a complete overhaul of its traffic stop procedures in response to community criticism over a video of another traffic stop conducted by the 9th Mobile Division on then 18-year-old Tae-An Lee, which took place on August 9th, 2018, just a few days before Mr. Parker was pulled over. Notably, the revised procedures prohibited officers from removing occupants from their vehicles and obtaining consent to search as a matter of routine. Overall, the Louisville Metro officers get an F for fabricating an excuse to conduct an illegal traffic stop. I do not know what was going through Mr. Parker's head during this traffic stop, but I would imagine that he chose to consent to the officer's request at least in part out of concern for the well-being of his family, and I certainly cannot fault him for prioritizing his loved one's safety over his constitutional rights. I commend Mr. Parker for remaining calm and collected throughout the encounter and for following up this interaction with the proper legal action.